Good night. This is U.S. Immigration Attorney Sharifa Tharb. I am here live to take your U.S. immigration related questions. Go ahead and put your questions in the comments so that I may answer your questions. So I have a great topic to talk to you about, and tonight I want to talk to you about the prospect of employment in the United States. So I get so many questions about just coming to the United States on a B2 and getting a work permit. And it doesn't exactly work that way. And so I want to explain to you how things work, especially with the employment-based, in general terms, the employment-based green card process or the employment-based visa process. And as well as the work permit, how to get a work permit. Now, if you are thinking, I want to come to the United States on my B2 and then apply for a work permit, you will be surprised. Because if you come to the United States on a B2, that's a visitor's visa, and think that you can you think that you can get a work permit, you will come and then realize that you cannot do that. Work permits are only for certain individuals who are applying for benefits. So benefits in the United States. So they qualify, they're applying for adjustment of status. That's applying for the green card while being in the US. Or they're applying for a form of relief like asylum in certain cases, or certain types of humanitarian visas. However, you cannot just come to the United States and apply for a work permit. And so that's where the consultation is very important. It's very important that you schedule a consultation to make sure that you're on the right path before leaving your country, coming here on a B2, and before applying for a work permit that you may not qualify for. So now, with employment-based green cards, there is also an additional problem if you're here without status. So that's something I also want to touch on, because I get the question, well, I overstayed, I'm not going back. Can I just have an employer apply for me? And unfortunately, it's not that easy. There are ways. If you have an employer, there may be ways for you to still get an employment-based permanent resident, but it's going to really depend on whether you qualify for a waiver. So is there any way I can stay with my baby who's born in the US? So unfortunately, hi there, Nikki Bliss. Unfortunately, having a US citizen baby alone will not qualify you for status automatically. Your baby would have to be 21 or over to be able to file for you. So let's see. So our rich chick. He's in Ghana and I'm in the US. I'm 56, he's 35. What's the likelihood of getting him here? So if you're basically asking if age matters, it doesn't have to matter. So exactly, you just asked the question that I was assuming you would, and will age play a factor? And so this is a great question for anybody who's listening. Does age matter in the marriage-based green card? Now, keep in mind that if you have really gotten married for love, you do intend to spend your lives together, you qualify. Nothing in immigration law says that you will not qualify if you have a certain amount of years between you. Now, in some cases, yes, the officer is going to look further into your case, or they're going to scrutinize your case or your application, because when they do see the age difference, they want to make sure that they've thoroughly reviewed your application to see if this is really a bona fide marriage. And so that's where it's very important to put a strong application together when you're applying for this. But the short answer is a rich chick. Age does not matter. What matters here is that you show strong evidence that your marriage is real or your engagement is real if you are engaged. Any tips from marriage green card interview? So yes, make sure you carry updated evidence. Make sure you touch base with your spouse. Talk about, go over your facts. Go over your your background together. Go down memory lane. Make sure that the both of you are consistent with how you remember things. I know that in a relationship, sometimes one spouse is the person that always remembers everything, and then the other spouse is the one that really doesn't remember anything. And so that the interview is definitely not the time to do that. So sit down with your spouse, touch base, make sure that you are both on the same page when you're going in. Can someone on government assistance give a spouse green card? Yes, absolutely. What matters here is even though you may be getting public assistance, what really matters is, do you meet the income requirements? Now, sometimes getting public assistance means that your income, so at the same time, that indicates that your income may not be enough to qualify your spouse. In that case, you could get a joint sponsor. So the joint sponsor could be the person that steps in to show income that they can help to support the immigrant spouse. Can a mother that just got a green card apply for her 41-year-old daughter who is single with kids? Yes, and the kids can go along as long as they're under 21 and unmarried. So keep those questions coming. These are great questions. So keep these questions coming. That is exactly why I'm here. I also come with a topic to talk about while your questions come in. And so the topic that I'm going to talk about, or I have been talking about, is basically who can qualify to work in the United States. So there are different ways to be able to work in the United States. And those ways are through a work permit, through employment-based visa, so that's a temporary visa, or through the employment-based green card. Now, however, in those cases, you have to make sure you qualify in every way. It's not as easy as coming with your visitor's visa and then getting a work permit. I wish it was that simple, but it is not. You have to meet specific requirement for each type of category of employment-based visas. So what if the child is above 21? So if the child is above 21, and they're a U.S. citizen, they can apply for you as the immigrant parent. If the child, if you're applying for is over 21, then they're going to fall into a different category. If you're the sponsoring parent, they're going to fall into a different category, and it's going to be a longer process, and it all depends on whether they're married or unmarried. So how long is taking now to bring my husband? I sent my I-130 and received on April 19th. So you could be looking at 18 to 24 months. You can also look at the service center, Liz, where they can give you a more accurate range of time that they are taking to process these types of petitions. So if you go to USCIS.gov, scroll down to case processing times, you look up the service center. You can find the service center based on those 3 first letters in your receipt number. Look at the range of time that they're taking. And yes, Liz Marin, it is painfully long. And believe it or not, if you're a U.S. citizen, I don't know if you are, but if you're a U.S. citizen, that 18 to 24 months is short, believe it or not. So let's see. So Nikki Bless, I think I missed your the question. I think I did, Nikki. Can you retype, please? I don't see it. So how long does it take when a sister files for a brother that is here in the US? So if the sister files for their brother who is here, that's touching on a more complex issue, because if your brother is already here and he's out of status, or he will be out of status, he will not qualify to apply for permanent residence here. He has to be maintaining some sort of legal status to be able to adjust status. That means to stay here and apply. So that is one situation. The other is applying for your sibling is not a quick and easy solution. By all means, if it's the only way for your brother to get permanent residence, then it may be an option to explore. But how you're going to go about it is going to depend on his status here. How long has he been here? Has he overstayed already? Because that is actually a major issue here. Because if he has overstayed, then he cannot apply for permanent residence here through you. And he would have to apply for a waiver to get forgiveness for the overstay to be able to finish his process, and that would require him to have a U.S. citizen or legal permanent resident spouse or parent. So right now, 2 sibling petitions are taking 14 years at minimum. I notice I think Jamaican, I think that's Jamaican, like I'm assuming it stands for Jamaican. But in this case, in Jamaica, it's taking about 14 years. Hello, one of my colleagues came to the United States with fake degree certificates and pursued masters. So that could very well be considered misrepresentation or fraud. And so that is a serious charge. And so if they are if they're concerned about something, or they're thinking about applying for some other immigration benefit, they need to get legal advice about, their process. Hi there, Dark Horse 425. How long does it take for a sister to file for a brother that is living here in the US? I answered that one. Does the mother have to be employed who just got the green card in order to bring her adult kids here? So if she's not employed, she will have to show that she has a joint sponsor who can step in and support the kids, and show that they can support the kids. Okay, so Naj, ready to talk about your topic. Yes, it is a hot topic, and so I'm definitely going to touch on that. Sometime I just like to get through the questions and then we'll go back to the topic. Is USCIS backdating applications because of COVID, because they're taking really long to reschedule? Yes, call me. That is what's happening. So it's backlogged, and so they're trying to catch up right now. But COVID was a part of it. It was a problem before, and it got even worse with COVID. And remember that there were thousands of cancellations across the country, and so they're trying to even catch up on those cancellations. Can you work while waiting for your paperwork to be approved without applying for a work permit? So Shadad, if this is an employment based, it really depends on what you're applying for. Some immigration benefits, while it's not permissible to work without a permit, it doesn't penalize you for working without a permit. However, unfortunately, with employment-based visas or green cards, they definitely don't look kindly on that. And so once you are found working without a permit, if an employer is applying for you or you're applying in some way to get employment-based green card or visa, and you're found working without a permit, you will be denied adjustment of status, and you could even be denied the temporary employment based. Jay Hind, so yes, he overstayed. So Jamaican Kitty, if he overstayed, you as a sibling, it's highly unlikely that you would be able to assist him to fix his status. Now, by all means, schedule a consultation, because remember, the information that I'm giving you tonight is general information. It's not personal legal advice, but it can certainly be helpful information. And so for this is how it would go, right? If you as a US citizen sponsored your sibling, your brother, it would take about 14 years, right? But say he manages to stay here without status for 14 years. At that point, he doesn't qualify through you to get adjustment of status. That means to stay here and apply for the green card, he has to go to the embassy in his home country for that final interview. They're going to process it. They're going to send a notice that he has been scheduled at the interview. But guess what? If he leaves, he is going to face a bar of 10 years. And so he will be in for a nasty surprise if he leaves the country to go to that interview, because they're going to say, well, you don't have a waiver approved. That's forgiveness for the overstay, and you've already left the US. That means you're barred from getting a green card. We're forced to deny you while you apply for a waiver from the outside of the country. But here's the other tricky part. Your brother would have to have a U.S. citizen or legal permanent resident, spouse or parent who will experience extreme hardship to be able to get an approved waiver. So there are different moving parts here, and the number one obstacle is the length of time that it will take. The number two obstacle is the fact that he still wouldn't qualify for adjustment of status, and he would need a waiver. If parents have visitor's visa and parents is overstayed in the U.S., can citizen daughter file for them? That could very well be a possibility, yes. So a U.S. citizen son or daughter who's 21 and up can file for their parents even though they have overstayed, as long as they came in with a permissible visa. So that is a possibility. However, to confirm whether your parents will qualify specifically, of course, a consultation would be required. Thanks so much for the love, by the way. How long does it take for a mother to apply for her adult child? Does the mother have to be working? So it depends. Now, here's the thing. There are still additional questions I would have before I can answer this question. What is the marital status of the daughter? What is the immigration status of the mother? Is she a U.S. citizen or a green card holder? And so that would be able to give me an idea of how long. I can tell you U.S. citizen and green card holder parents who are sponsoring an unmarried son or daughter who's 21 and up is taking about 5 to 7 years right now. So let's see, how long does it take for a mother? Okay, can someone who receives support from the government for having a disability get married to a foreigner? That could be a possibility. However, it depends on how much is the income that spouse is making, and it may be necessary for them to have a joint sponsor to be able to help them to meet the income requirements. If a sibling overstayed on their visitor's visa, would that prevent the other sibling from getting? Not necessarily. It just depends. So if the facts in your background indicate that somehow you and your sibling, well, generally not. No, but I don't know what your facts are, and I don't know if something in your facts would indicate to the officers that if your sibling overstayed, you could too. So it depends, really depends on what they've found in your background, but generally that's not necessarily the situation where you automatically get penalized for something that your sibling did to violate the immigration rules. So let's see. So if your passport shows a different occupation than what you're doing now, does it matter at the embassy? So no, they may ask questions, but remember that the passport lasts for 10 years, and you can find 10 different jobs in 10 years. So it's not usually an issue. So Candy Girl, sorry, not sure if you answered. Don't think I saw your question. I applied for citizenship approximately 6 weeks. My green card expires in December. Should I extend my green card? So while the green card isn't absolutely necessary for you to apply for citizenship, where it is necessary is for you to have as proof that you're a permanent resident. And so in that case where you want to make sure that you have your ID to show that yes, you currently hold status, and yes, you are able to legally work, that green card would definitely be important. However, not having the green card, or if it expires while you're going through citizenship, will not necessarily mean that you're not going to get citizenship. You're still a permanent resident despite the fact that your card has expired. So what is the minimum time for marriage-based green card process to get a 2-year green card? So less than 2 years. If you're married for less than 2 years, you're going to get that 2-year green card instead of the 10-year, and you'd have to renew in 2 years. How much time takes the USCIS to approve the I-360 as religious worker at the California Center? If you go to the USCIS.gov website, you scroll down on case processing times, you can look it up yourself and you can see that accurate range of time that they're taking. How long does it take when you file for a spouse, child as a green card holder? If the child is under 21 and unmarried, it's taking about 18 to 24 months right now. However, keep in mind that that is subject to change, just depending on how many applications come in. How much does it matter if you take help from the government while waiting on your green card? So it may. Now, how did you obtain it? Did you truly qualify for it? Because if they do find that you obtain benefits that you didn't qualify for, that could very well affect your process. However, if this is something that your state offers that you did qualify for as an immigrant, it may not. So it really depends on the facts in your case. And if you're really concerned, schedule a consultation, and let's talk more about that. I didn't hear an answer to the occupation listed on the passport. So honey bun, no, generally it would not affect you at the embassy. So I don't want to be married, and more can my spouse still apply? So I don't want to be married, and more can my spouse still apply? I'm sorry, I'm not unapologetically ticky. I am sorry, I'm not making sense of that. Can you just rephrase in a way I can understand? Okay, so call me daddy, such as government assistance or food stamps. So it really depends. Did you qualify for it? What did you say in your application, and so forth? Can the green card holder mother apply for her single daughter? Can she stay and work while waiting? So it's unlikely that your green card holder, can the green card holder mother apply for her single daughter? It's unlikely that she would be able to stay and work. She would need a work permit for that, and she'd have to qualify for adjustment of status. But if she doesn't have a status, or she just has the B2, it's highly unlikely that she would qualify. Schedule a consultation, get personal legal advice, because you really need legal advice, especially if this is what you're considering doing. How long after biometrics do you receive your EAD? It's all over the place, Nikki Bless. So I usually say right now it's taking about 7 to 11 months to get that work permit after filing your application. So you don't want to be married anymore. Okay, I see. So let me see if I find that back. So I don't want to be married anymore. Can my spouse still apply? So what you need to do unapologetic is schedule a consultation. Let's talk about why you don't want to be married anymore. Is it that you're being mistreated? Are they subjecting you to extreme cruelty? If that is the case, you can actually apply on your own if you've lived with your spouse in the US and you're here. Then you can apply for this. And even in some cases, if you're outside of the United States, your spouse is an employee of the federal government or in the military, then you could possibly qualify from outside of the United States for this. So schedule a consultation and let's talk more about this, especially if you're being mistreated, you're being abused, or subjected to extreme cruelty. I'm not sure if I understand. Will they question your occupation listed in the passport? So yes, honey bun, they may. I can't guarantee what the officer will do at the embassy, but they may very well ask you what you do for a living. However, the passport, that you're not held to working, that staying in the same job that you had listed in your passport. Remember, the passport is a document that lasts for about 10 years, and you could get 10 different jobs over the 10-year period. And so you're not held, you're not expected to commit to the job that you had while you were getting your passport. So many times people change their occupations and it's a non-issue. So it should not affect anything. But if there's something you're really concerned about, schedule a consultation. We can definitely talk more. Nakisha, you are welcome. So my fiance got pregnant for me while she visited me for the first time, and now she's pregnant. She's 4 months pregnant. So I don't see the, and we are not married yet, but are engaged. So if you're a U.S. citizen, or if your spouse is a U.S. citizen, you can do the fiance visa, where you or whichever one is the immigrant can come to the United States on the fiance visa. And surely, I don't know what your situation is. I hope that you both are happy about it, and this is going to be, this is something that you wanted, or that you are looking forward to. However, having a baby together in this context is not exactly a bad thing, because it shows that you do have a real relationship. So schedule a consultation if there's something you're concerned about, to get personal legal advice, because remember, the information I'm giving you tonight is not personal legal advice. It is general information. So if you are looking at options on how to come together, call, schedule a consultation, and let's get started. The fiance visa may be the option for you, or even the spouse visa if you do get married. Can't I get an H-2B visa while on filing? So no, the H-2B is a temporary visa, and you have to have temporary intent. When you're filing for green card, guess what? That is showing permanent intent, and so those are contradictory. If you have lost your passport with your visa, would that affect me with filing for paperwork? So you usually have to show through some way that you entered the country with permission, and that could be one way. But if you find your I-94, that could be a replacement, or you could apply for a copy of the I-94, or go onto the website where you can get the I-94. Can someone apply for a work permit while waiting on the I-129 filing? So usually with the work permit, you have to be in the United States. If you file the I-129, which is usually the fiance visa, you are probably outside of the United States, and you can't apply for the work permit if you're outside of the U.S. How long does it take for a U.S. citizen to file for children under 21? So it's taking about 18 to 24 months. If my green card parent is filing for me, can I still get an H-2B visa? It's highly unlikely. You'd really have to come good with evidence to show that even despite the filing after your H-2B visa is up, you will return to your home country. And so that's the problem right there. All right, so that is it for me tonight. I didn't get to touch on the topic. Well, I sort of did, right, with the employment-based and the employment-based visas, employment green card, and work permit. However, I will be back tomorrow at around 9 p.m. to answer your questions. Our conversation doesn't have to end here though. You can hop on over to Instagram where we can continue this conversation over there. So I actually am scheduled to be there at 9:30, and it's already quarter to 10. So I have to head over there. You can hop on over there. As a matter of fact, that's where most of my content is, where you get updates, where you can get tips throughout the day, and then you can join me on live there. So we can actually have an hour together on TikTok and on Instagram. So follow me over there. And or if you really would like personal legal advice, you want to have a plan, then go ahead and schedule that consultation. Go to the link in my bio. It'll take you to the website where you can schedule with a scheduling coordinator who is actually available up until 11 p.m. tonight. You can also do online chat or complete a web form, and the scheduling coordinator will get back to you. So I hope to see you on Instagram in 1 minute, but if not, I'll see you tomorrow or speak with you in a consultation. Have a good night.